How's everybody doing today? I guess you really can't answer, but great to have you here. I'm excited to talk to you a little bit about employment screening. So we will just kind of dive right into this. A little bit about Peopletrail. We're actually located in Draper, Utah, which is just a little bit south of Salt Lake City. So we're getting quite a bit of rain today. So anyway, I don't know what it's like across the country, but we are getting drenched here. So let me just start by giving a little legal disclaimer. I am not an attorney. I don't play one on TV. And just want to let you know that if you hear anything in this that you decide to implement, it's probably a good idea to run it by your own legal counsel and just make sure that everything I'm saying is sound. So just wanted to put that out there. Although the things that I tell you I've had a lot of experience in, so I think we're pretty good. I just want to make that disclaimer. Moving forward, I know that Scott went over some of this, but I just want to kind of put a timeline on it so that we can understand where we're going. So, you know, some of the learning objectives that we're going to cover today and the timing. The most important background checks an employer can conduct. I'm going to spend about 8 minutes talking about that. And then kind of an important topic that's been going on is why post-hire screening or screening candidates after they've actually been hired. That's on the rise. I'll spend a few minutes talking about that, about 8. And then we'll go into you know, whether or not employers are permitted to screen for prescription drugs and maybe some of the things surrounding that for about 8 minutes, and then spend some time talking about the common flaws in employer drug testing programs, about 7 minutes on that, and I-9 mistakes, about 7 minutes, and some of the risks of using social media to screen candidates, take about 7 minutes on that, and then should leave about 15 minutes for some questions, and you should be able to type in some questions, and I may be able to get to a few of those from there. So first off, I guess the first trending topic that we're going to look at is why is it important to verify a job candidate's past work experiences and educational accomplishments. Now, I wouldn't say that this is the most important screen for every employer, but there are some compelling reasons to consider adding them to the screening mix, and I want to just kind of go over some of those. So let's take a look really quickly at why that might be. There's a lot of checks available for background screening. As you can see, I mean, it's important to understand that a background check can consist of a number of different components. So what's important to one company may not be important to another company. Some people may be really focused on the criminal aspect. Others may, you know, have drivers out there and they don't want them driving around killing people, so they want to do a driver's check, and they want to make sure that their liability is limited in that way. So there are a lot of different checks that you can look at for an employer, as an employer. One of the things that I wanted to bring out again was the credentialing, and if an applicant wants to pad their resume, it's really a calculated risk for them. According to the latest benchmarking reports, 45% of all resumes contain at least one major error on them, or one major fabrication, so they're not telling the truth. 70% of employers spend less than 5 minutes reviewing resumes, and 42% of small businesses don't verify previous employment. And so really, you know, employees or prospective employees, applicants, they know that this is the case, and so padding a resume is not really a big deal, and it's a calculated risk, like I say, and something that they can do and get away with a lot of times. Something kind of interesting is we've had some creative embellishments over the years, and or errors that we've uncovered, and it's really funny what people come up with. One of them claimed to be a Nobel Prize winner, and of course they weren't. One other one claimed to be a former CEO of the company, which they were actually applying for, and that obviously didn't happen, and they were not considered for the job. One of these people claimed to have worked in a jail, and they were actually serving time there. We verified that. Someone claimed to be employed at 3 different companies in 3 different cities simultaneously. And we've had several people that have attended colleges that don't even exist. And so we uncover that all the time. In fact, we have a system that actually goes out there and looks for colleges that are just these fake colleges. And you would be surprised how much effort people put into verifying a college degree. I mean, people spend so much money to be, to criminalize this on the other end. So we'll call them. They'll even verify that they went to the college. They'll have a registrar's department, but they're really not even a legitimate college. So those are things that we're finding that are happening. And finally, one guy claimed to be HVAC certified and later asked the hiring manager what HVAC meant. So, people are putting things on their resume and saying that they are qualified when they're really not. So it's really important to be digging a bit deeper and find the wolf in sheep's clothing. Moving on, if we look into a candidate's past work history, many times we can reveal insight into their job stability and possible loyalty to the employer. So that's why, experience and education are two of the most common types that are falsified. So it's important to note that an employer must obtain permission from the candidate before conducting any check, including an employment verification. You can't just go searching into their background without asking them about, if you getting permission to go forward and do an investigation. Anytime you compile information about a consumer or a prospect or candidate, you're compiling a consumer report, so you are bound by the FCRA. It's not just credit that you're looking for. Anytime you're compiling information, you're putting together a consumer report. So you must obtain permission. Also, it's possible, very possible, that the candidate can deny permission to a potential employer to conduct a previous employer search or to look at his previous employment, but you can still require them to provide documentation like a pay stub or a W-2, any other tax documentation that can prove that they were actually employed. So those are ways that you can kind of get around that if they decide not to give you permission. Another thing you want to look at is the nature of the job. What is it that they're going to be doing? If they're going to be not involved or driving a company vehicle or anything, there may not be a reason to do a driving record. But talking about, most companies are concerned about the criminal background, so you want to be careful about that too. Are they going to be put in a situation where they can be in a potential area to steal something or cause some harm to somebody? Are they working around a lot of people? You kind of want to look at what it is that they're doing. So again, some employers place more importance on the driving records or professional licensing or credentialing. Others, may want to look more at their background. So it is important to look at that, and a healthy mix of all of the screening tools are really what it is that you want to kind of focus on and see where you're at with your situation. So changing gears a bit to the second trending topic we're touching on today, why it's important to hire or to do post-hire screening and why that's on the rise. So this may or may not relate to you, but it's something that I wanted to kind of touch on. And to address this plain and simply, insider threats are growing. And so we've seen in the news the exposure of government secrets by Edward Snowden, the 2013 Navy Yard shootings in Washington, D.C., and the situations like the Morgan Stanley hack, and more recently, I guess, the holiday party shooting in San Bernardino. These have all increased the focus on the post-hire insider threats, and companies are starting to look at that. So from embezzlement, fraud, and theft to child molesters and active shooters, there's a lot of insider threats within your organization, and these come from anyone with access to workplaces, including employees, contractors as well, temporary workers, and we've seen a lot of even ex-spouses. So an employee's ex-spouse, not that you're going to do a background check on their family members, but that's something that we've seen as well. So just because an employee met your job requirements at the time of hire, it doesn't mean that nothing has happened since then or while they've been employed that could be of concern for you. And I just want to kind of throw up a chart here that shows the trends here. But these are the percentage of companies that are conducting post-hire screening, and you'll see that over the past couple of years, it's been on the rise. So that's showing a trend, and we're seeing that people and companies are making that part of their screening process. Now, in some industries, for instance, transportation, healthcare, ongoing screening is a compulsory thing, so they actually have to. We aren't in agreement with companies or industries being compelled to do things, but we all know that we're surrounded by regulation, and a lot of times we're in a situation where the government mandates that we do things. But even beyond the industries that are compelled to rescreen, we're continuing to see that companies, even that aren't mandated, are rescreening employees, and they're doing it because they want to maintain a safe and secure environment. Some of them to protect their brand. There's a lot of PR issues out there if they get into trouble. Some to ensure that the employees are moving into the new positions are qualified. So there's a lot of reasons people and companies are doing the post-hire screening. So something that's important to know, the due diligence, post-hire due diligence can identify things that may have been missed initially. So new threats that often arise, changes in circumstances, it happens, and we've seen it all the time. So it can also reveal new threats that arise when they change jobs or their family situation, they go through a divorce. Anytime there's life-changing situations when they move, those things, that's definitely when things like that happen, when problems can occur. So with many organizations whose employees have access to sensitive personal information or physical access to facilities, it's important for employers to review and reinforce their policies around the rescreening. So if you have any questions on that, rescreening is important. That's kind of a summary of that section, but a lot of companies are moving to the rescreening, and that's something that we're seeing as a big trend in the HR world. So moving along, with the rise in awareness around prescription drug addiction is our discussion topic number 3. Let's talk a little bit about this issue and what employers are legally permitted to do. Many employers are really concerned about the impact of prescription drugs in the workplace. I mean, obviously, a prescription drug, it's something that, I recently went through a surgery, and obviously I needed prescription drugs for the pain. I still have to go to work. So there's kind of a conflict there. It also causes problems. It can cause impairment. So where is the line that we draw between prescription drug use being used in a productive way, and where does it affect the workplace and the safety of other employees? And I think that's a big concern of what people are seeing and what people are looking at. It actually studies have showed that it has increased the potential for on-the-job accidents. It also negatively impacts job performance when people are on prescription drugs that cause disability or slow for pain. It helps them to feel better, but it also slows them down a bit. They become a little bit intoxicated. It also provides a stronger impetus for theft, especially if they're hooked on drugs and they need to find a place to support their habit. And it also negatively impacts workplace safety. Employers are finding out quickly that the use and abuse of these medications is a serious problem, and it does deserve their attention. In a 2011 survey done by the National Institute on Drug Abuse, there are about 20% of Americans older than age 12 that reported using prescription drugs. I think that's interesting. 12 and older is where they put that, in a non-medical manner at some point in their life. So they may finish their surgery process and then they continue to use those drugs just to get higher to feel good. NIDA also reports that prescription drugs are, after marijuana and alcohol, the most commonly abused drugs in the United States. And recently, the Centers for Disease Control and Prevention, they classified this type of abuse as an epidemic, and they indicate that it is the fastest growing drug problem in the U.S., with 1 death in every 19 minutes. So not only are these drugs making people feel good, but they're also killing a lot of people because they're becoming so addicted that they're overdosing on them. And that's a pretty substantial statistic there, that because of those drugs, every 19 minutes someone is dying. But this being said, there is some evidence that prescription drug use and abuse is a growing problem in the workplace. According to Quest, they're a leading drug testing laboratory. They said that there's been a marked spike in the incidences of employees testing for positive for prescription opiates, and I find that in my business as well. We do a lot of drug screening, and we've seen a lot over the last couple of years, a big spike in the prescription opiates, more than 40% rise from 2005 to 2009. But unlike illicit drugs, for which most U.S. companies or employers can test easily and legally, prescription medications present a number of challenges to the organizations because they're legal drugs. I mean, they can be prescribed. So the mere presence of these substances in a drug test does not constitute an offense like with illegal drugs. So that's one of the issues and one of the problems that we're seeing. It's important to keep in mind that employers using prescription medications are protected by the Federal Americans with Disabilities Act, or you may know it as the ADA. And that limits an organization's ability to question employees or anyone, contractors even, on the use of such drugs unless an employee's behavior is compromising the workplace safety or it's otherwise indicative of a reduced ability to perform their job. But workers have rights under the Act, the ADA. They have the right to claim privacy with respect to their health information, and they can refuse to share details of medication use with their employees, and that's really something that you need to be careful about too. You can't just go asking your employees what drugs, what medications they're on. If they voluntarily release that to you, that's a little bit dangerous as well, because you now know about it and can make a decision based on that. So you need to be really careful around that kind of stuff. Some legal cases to support this. This is a recent situation. It can provide some guidance to employers as you navigate the issue. In 2007, which is a while ago, but it still is applicable here, an automotive parts manufacturer was concerned about what it believed to be a higher than normal rate of workplace accidents at one of the factories. And so this employer suspected that there was some drug use going on. And so they decided to go ahead and just ban all use of several prescription medications, and they required their workers in the facility to take a drug test that comprised of a panel 12 panel substances, which normally, you know, the DOT is a 5-panel. A lot of employers are moving to a 9-panel drug test. They actually opened this up to a huge 12-panel substance. 5 of them were illegal drugs, and 7 were the commonly abused prescription medications. And I'm not saying that a 12-panel substance abuse test is bad. I think that's a good thing to do. We just need to make sure that your policies reflect that. But the company then took adverse action, including including suspension and termination against all or several of the employees that tested positive for one of the substances. And most of them actually had a legitimate reason and a prescription for the medication. So there was a class action suit. The U.S. Equal Opportunity, or the EEOC, got involved, and they initiated a lawsuit against the company on the basis that the drug testing violated the employees' rights under the ADA. And they actually won that. The case resulted in a settlement of $750,000 in favor of the EEOC, and they contended that the employer's action constituted an unlawful medical inquiries and required medical examinations that were not job-related or consistent with the business needs. So those are things that are important to be aware of. And now the EEOC, in my opinion, they overstepped their bounds in a lot of areas. I was actually back in Washington, D.C. a couple of, actually it was last year, and they had the head of the EEOC come and speak to us, and she told us that they were actually actively pursuing discrimination claims, and that, you know, they were looking for revenue. And it was kind of interesting to me that they're actually out there suing companies because they want to kind of build themselves up and get some revenue and be able to go out and have a bigger footprint and bigger presence, because the funding through taxpayers is what they get, but they also create revenue by these fines for employers. So I thought that was kind of an interesting take, but not something I had prepared in my presentation, but something I was just thinking about. So they actually do have recommendations that they've put out, and if we can just kind of follow the recommendations that the EEOC puts out there, then I think you're safe from a lawsuit. One other side note here I'll go on, and it doesn't have to do with prescription drugs, but it does have to do with an EEOC lawsuit. I had a client that was sued by the EEOC. They brought a claim against them. It was a discrimination claim, and we were able to go to them and say, look, we followed your exact recommendations on this very case, and we showed them where we followed their exact recommendations, and they dropped it immediately. But that just shows that they're still going out and suing without really looking at what's going on. So they're taking a very aggressive stand. So if you follow the recommendations that they have on the drug testing side, you're going to be okay. And some of those things are, there are some exceptions to, I got a little bit off track, but there are some exceptions to the rules with safety-sensitive employees. If you can prove that they're in a safety-sensitive position, then you have it written in your policy, then that's an exception. I mean, if you have somebody riding a forklift and they're high on medication, whether they've got a prescription for it or not, that's a safety problem. So it's something that you want to look at and make sure that you have documented in your policy. So that's an exception. Another exception is those companies that are regulated by the Department of Transportation. There are specific rules in 49 CFR 382.21. If you have DOT employees, drivers, truck drivers, then you're probably familiar with this, and they have some very specific rules that are exceptions to this. And one other thing I want to point out while on this slide still is that you should always consider using an MRO. And if you don't know what an MRO is, we can talk about that later, but it's a medical review officer that is trained in pharmacology, and they actually look at the drug to make sure there's a legitimate reason for the drug to be in their system. So moving along to hot topic number 4. Just a statistic here, about 65% of mid to large companies currently conduct pre-employment drug testing. And with the changing laws of marijuana regulation being adopted across the country, they're starting to take a look at their drug screening programs in 2016. While employers are taking a helpful step towards creating a safer and more productive workplace, they have there's many common mistakes that they've made in the development and management of their drug testing programs. And so that's why I wanted to bring this up and talk about it, some of the common flaws employers make in their drug testing programs. So we'll just move along to there. So again, what's important to know about drug testing programs? Well, a program that's inadequate could fail to detect an individual whose abuse of illegal drugs or other illegal substances. So flat out, you just can't detect it. These individuals can pose an increased risk of causing workplace accident, which results in costly litigation, reputation damage for the company, PR issues, and for companies that have state or federal contractors, employing an individual that abuses substances could pose compliance risks. So there's those issues too. So to help minimize these risks, employers should evaluate 4 components of their drug testing program, and I'm just going to go over those really quick. One of those is random drug testing and limiting the time between notice and testing. This is a big one. We have clients that, they'll have their random drug testing, and some of them do it on a quarterly basis, so they get the list of names for their people, and they say, okay, sometime in the next quarter you need to go down to this clinic and get a drug test. Well, that gives the employee 3 months to go down or figure out a way to beat the test. And they really don't even need 3 months. If an employer gives a person a couple of hours or says, here, go down and take this drug test, it's very easy for them to stop off at their brother's house, have him, void in a cup, put that in a urine or in a condom or a balloon or something like that, tape it to the inside of their leg, go into the clinic and use a substituted sample. So limiting the time between notice and testing is a really big one. The other important part is developing a truly random selection process. So, those things can be challenged. There are computer programs out there. There are companies that use a truly random process. But if you're selecting someone every time, or you don't like someone, or one of your supervisors doesn't like somebody, it's possible for that to be tainted. Or maybe they see somebody doing something that looks like they're on drugs. Unless they can't call for a random drug test. That would be a reasonable suspicion test. And so a lot of people are calling those random tests, and you have to be very careful about what you do on that. Moving to the next couple, you need to clearly understand the regulations. There are state regulations that are out there as well as the federal regulations. Most of the time, if you're working on federal contracts or you are a DOT employer, those rules, the federal rules, trump any state laws. So that's important to know. So even with the new marijuana laws coming out, and there's a lot of states, I'll go over that in the next slide, but even with those new marijuana laws, if you're a federal contractor, the federal laws trump that. So whether that's legal to have a marijuana in the state or not, if you're a driver and regulated by the Department of Transportation, then you definitely are okay on that. So things to consider: the Drug-Free Workplace Act, those are federal, and again the DOT has the Federal Aviation, Federal Motor Carriers, which is the drivers, the FRA, the FTA, the U.S. Coast Guard, all of those different divisions which have their very specific rules. And then there's also the Department of Homeland Security, which has some specific rules as well. So about 65% of mid to large companies conduct pre-employment drug testing, but only 39 of those have implemented a random drug testing program. So what does this mean? It means that it could expose a substantial, there's a gap in when they hire them, and maybe they were not using drugs when they were hired, or maybe they stopped using drugs for a couple days to be clean on the drug test, get employed, and then start back up again, and that happens. Some drugs don't stay in your system very long, and these people know this. Marijuana stays in the longest for probably up to 30 days if they're a heavy user. Cocaine, heroin, that stuff can be out of your system in 2 to 3 days. So all a person has to do is stop using for a couple days, and they can come up clean on a pre-employment drug test. And if you're not random testing, then they can start back up and cause those problems. So that's something to look. Also, testing of contingent workers. That's something that we've seen. That's important. So if you have a large contingent workforce, then definitely look at that. That's something that's important. Here's that slide I was talking about earlier about the marijuana. 23 states plus the District of Columbia allow some form of medical marijuana use, and several other states have pending legislation. But like I said before, the Federal Controlled Substance Act still classifies marijuana as an illegal Schedule I drug, and I think it still will for quite some time. That's going to kind of hang there. For one reason, changing a federal law takes an act of Congress, literally. So, that does not happen quickly. So the conflict between state and federal laws does put employers in a tough situation, I'll be honest, and that's something that we're going to kind of address here now. One thing you should consider is outlining a specific drug policy to address medical marijuana. And there's a lot of language out there and a lot of people that put together policies, and we do it too. We have language that you can borrow from, which actually you can put in your drug policy. Some employers may elect to have a zero-tolerance drug policy, and that's okay. And I think they even excluding card-carrying medical marijuana users. Even if they don't have the federal regulations and they're operating in states that allow medical marijuana, the usage of marijuana can be restricted at your company. You just have to have a tailored policy that that spells that out. And then you may also choose to create a tailored policy that allows for medical marijuana usage. If you have low-risk jobs that you feel like, that's going to be okay, then go ahead and put that in there. The first page of the I-9, actually there's only one page, I think, on that, and it comes with enough rules and regulations to fill 69 pages of a manual, a how-to manual. Even though it's a very small thing, the I-9 is very complex. A one-page document, but there are so many rules and regulations, and that's the federal government for you. But it's no wonder that it makes the topic number 5 on our list. And so let's just dive right into that. There are a lot of common mistakes and actually human errors that can be made while completing an I-9 form. If an employer fails to complete or maintain the I-9 documentation correctly, you're going to fall out of compliance with Immigration and Customs Enforcement, which is the ICE rules. And companies are suffering harsh penalties on this. Fines for the I-9 errors begin at $110 per error and climb to the tens of thousands of dollars per error for repeat offenses and very serious offenses. If the employer has one form of per employee mistakes on each form, the financial penalties could quickly escalate up into the 6 and 7 figures, and we've seen that. There is an example. A well-known clothing retailer recently reached a settlement with ICE regarding the I-9 documentation violations discovered in a 2008 audit, and they'll pay more than $1 million in fines, and they must cooperate with the federal authorities by actually modifying their I-9 process and management systems. So in addition to the steep fines and the system upgrades, it's likely that this company incurred additional expenses with their legal costs, the added time for their employees to respond to the audit, and all of the other problems that it brought. So just throwing up some of the most common ones. Incorrect or missing forms, that's one of the main ones. Out of compliance with the 3-day rule, you have 3 days to get the I-9 done. And if that's not documented, that's very obvious in an audit. Failure to re-verify. A lot of times you'll have people that have expired documents, and it's important for you to keep track of those. Every time they expire, if someone has say they have a legal right to work in the U.S., but they're not a citizen, and their documents expire, how do you know when those expire? How do you keep track of that? And if you don't re-verify them, then you're out of compliance. Invalid identifying of documents. So that's a big one that we've seen too. Improper documentation maintenance. If you don't have a system in place to where you maintain all the documents, you have them spread all over the place. That's a big issue with I-9, and these are the 6 most common. The other thing is the lack of supporting documentation. There's now a requirement with E-Verify to do photo matching. So if you're using the E-Verify system, are you keeping supporting documentation so that you can actually go back and look at the driver's license or a picture ID from them to actually match the photo with the photo that they have on the E-Verify documentation or that comes up through there. And they'll get you for that. If you don't keep that documentation, even after you've re-verified, that's important to keep that documentation. So that's one of the things that are important to keep in mind. Some ways to simplify that and avoid some of these hefty fines. People are moving to electronic versions of I-9 compliance, doing everything online, or having an electronic version of that, and that's something that a lot of our clients use. is the I-9 compliance. So when you fill out documents, or the first page of the document, when the applicant or prospective employee fills out the documentation, it doesn't allow them to make mistakes. So if they do something wrong on it, it won't allow them to move forward. So electronic means are a really good way to keep in compliance with I-9. Last topic we want to talk about really quickly here is social media profiles. They're actually, why is it risky? I'm just going to throw up some statistics here. 84% of employers use social media to recruit. 43% use online search to screen candidates. And 1 in 3 employers disqualified applicants based on the information that they obtained on social media. So that's something that's, to me, is a little bit concerning. And really, what is the risk? They put job seekers on notice to keep their social media profiles clean, but it opens up employers to the risk that they will learn details about an applicant, such as race, age, religion, disability, or pregnancy, that are protected and legally cannot be taken into account when you're managing or making hiring decisions. So that's one of the big problems there. It's important to keep in mind that there are nearly 20 states that now bar employees from requesting access to employees' applicants' social media posts. So that's the blue states up there show that. But it is your right to view things that are publicly available, but just because you can view it doesn't mean that you can use it. So there was an example in the University of Kentucky. They paid $125,000 settlement several years ago for a religious discrimination claim. The professor claimed he was passed over for a job because of his views he expressed on social media about evolution on his website. So there are justifiable reasons to weed people out based on their social media activities. You can disqualify someone for, to be found posting racist jokes and things like that. Profiles that don't align with the applicant's resume can cause a red flag. They may conflict with what's said on their resume. And there are also positive reasons to explore profiles, such as confirming the applicants are creative, good communicators, well-rounded in their personal life. So, what are the guidance for employees here? It's with all the ambiguity, there is some guidance. First, you should consider separating the recruiting and hiring functions to help you solve that. Have the recruiters scour the social media sites and only relay the relevant information to the people making the hiring decisions. So an example, a recruiter may learn on an applicant's Facebook page that she's pregnant, but she doesn't pass that on to the hiring manager. That's one way to do that. You separate that. Also, make sure social media policies are clear and that the employees understand what will and will not be tolerated. And encourage your employees to set their privacy settings for social media accounts. Even if the information is labeled as private, posts can make their way through the internet grapevine quickly. And also encourage employees to use better judgment when they're creating a post. It is their right to say what they please, but if they don't want their boss to see what's posted, then they probably shouldn't post it. So that's pretty much the social media portion of this wrapped up, and I think we're out of time. I don't know if there are time for any questions, but we're pretty much close to the end. I think I went a little bit longer. Let me just